Okay, so here's something that happened to a guy named Trevor. Trevor got pulled over on a highway outside his city. Late afternoon, decent weather, nothing unusual about the day. The officer said his registration sticker looked expired. Trevor wasn't sure. He thought he'd renewed it. Either way, he pulled over, stayed calm, was polite. Here's where it gets interesting. During the stop, the officer asked to search the vehicle. Trevor said no. He'd heard somewhere that you could do that, just decline. So he did, politely, clearly. The officer searched the car anyway, and he found something. Something that shouldn't have been there. Trevor genuinely didn't know it was there. It had been left behind by someone who'd borrowed the car weeks earlier, but that explanation doesn't matter much in the moment. What matters in the moment is that it was found, and now Trevor is looking at a serious situation. Here's the part almost nobody knows. The charges were eventually dropped, not because Trevor had a miraculous lawyer, not because the item disappeared, because of a legal protection, one that's been part of American law for decades, that most people have never heard of. A protection that says, when law enforcement obtains evidence through a search that violated your constitutional rights, that evidence generally cannot be used against you in court. Trevor's refusal to consent mattered. The officer searched anyway without legal justification, and because of that, what was found couldn't do what it was supposed to do. The search happened. The outcome didn't. And Trevor didn't know this protection existed until after the fact. That protection has a name. It's called the exclusionary rule. And this video is about explaining it in plain language. What it is, when it applies, what it doesn't cover, and why understanding it changes the way you think about every piece of legal advice you've ever heard about police encounters. Because here's the thing, most legal awareness videos focus on the moment, what to say, what not to say, how to handle the stop itself. And that stuff matters, genuinely matters, but it's incomplete without understanding what happens after. The after is where this protection lives, and understanding it gives the before a completely different weight. Let me back up and explain the basics clearly, because this is one of those areas where a rough understanding is actually worse than no understanding at all. The Fourth Amendment to the Constitution protects against unreasonable searches and seizures. That's the foundational right. It requires that searches generally be based on probable cause, a reasonable belief supported by facts that something specific will be found. Searches of homes usually require a warrant signed by a judge. Searches of vehicles can sometimes proceed without one under specific legal circumstances, but those circumstances have limits. Now, when law enforcement violates that protection, when a search happens without the legal basis required, the question becomes, what happens to what was found? For most of American legal history, there wasn't a consistent answer to that. Evidence was just evidence. And then, in 1914, the Supreme Court established the exclusionary rule in a case called Weeks v. United States. The basic principle: evidence obtained through unconstitutional means generally cannot be used against a defendant in a federal criminal proceeding. This was extended to state proceedings through Mapp v. Ohio in 1961. The reasoning wasn't complicated. If illegally obtained evidence could be used freely, the constitutional protection against unreasonable searches would be largely meaningless. Officers would have no practical reason to follow the rules. The exclusionary rule is what gives the Fourth Amendment actual teeth. That's the foundation. Now here's the part that comes directly from the exclusionary rule and is even less known. It's called the fruit of the poisonous tree doctrine. Strange name, simple concept. If the original search was unconstitutional, the poisonous tree, then everything flowing from that search is also potentially tainted. The fruit, anything found, any additional evidence discovered because of what was found, any leads generated by the initial unlawful search, all of it potentially excluded. This is why refusing consent to a search isn't just about whether something gets found. It's about what legal status that finding would have if a search happened anyway without proper justification. When you consent to a search, you've removed the constitutional question. What's found is cleanly obtained. There's no poisonous tree to argue about. When you decline consent, and a search proceeds anyway without the legal justification required, you've preserved the constitutional question. You've left the door open for a legal challenge. You've potentially turned whatever is found into fruit of a poisonous tree. That's the difference between two letters and a legal protection. Sure versus the absence of sure. I want to be careful here because I don't want to overstate this. Important caveats. The exclusionary rule has exceptions, real ones. Courts have developed doctrines like inevitable discovery. If the evidence would have been found through legal means anyway, the exclusionary rule may not apply. There's good faith. If officers reasonably believe they were acting within legal bounds, some courts have applied exceptions. There's independent source. If evidence can be connected to a separate lawful investigation, exclusion may not follow. These exceptions are real. They've been litigated extensively, and they matter. The point isn't that the exclusionary rule is a guaranteed escape hatch for anyone whose car gets searched. It isn't. The point is that the constitutional protection has actual practical consequences when it's properly preserved. And those consequences are something most people don't know exist when they're making decisions at the car window. Knowing the protection exists changes how you think about those decisions. It gives them a weight they didn't seem to have before. Let me sit on Trevor's story for another second, because I think it illustrates something important that goes beyond the legal mechanics. Trevor said no to the search. He'd heard somewhere you could do that. He didn't know why it mattered beyond the immediate moment. He didn't know about the exclusionary rule. He didn't know about fruit of the poisonous tree. He just knew you could say no. That one piece of information, just the existence of the right to decline, led to a decision that preserved a constitutional question, which ultimately mattered enormously. Now imagine Trevor didn't know he could say no. He says, sure, the search happens the same way. The same item is found. But now there's no constitutional question. Now the protection doesn't apply. Now the outcome is different. Same situation, different knowledge, completely different ending. That's what legal awareness is. That's what this video is about. Here's how this changes the way you think about encounters in practice. Most people, when they hear advice about traffic stops and searches, think of it in terms of the immediate outcome. Say no so nothing gets found. That's the frame. And while that's not wrong, it's incomplete. The deeper reason to maintain your constitutional protections isn't just about preventing discovery in the moment. It's about preserving legal options that only exist if the constitutional question was properly handled. An attorney can challenge an unconstitutional search. An attorney can argue for exclusion. An attorney can potentially get tainted evidence removed from a case. An attorney cannot undo consent you already gave. That's the asymmetry that matters. That's what changes the calculus. Let's talk about what this looks like practically across different situations. At a traffic stop, when the consent question comes, "Officer, I don't consent to searches." You've heard this before if you've watched any of our other videos. But now you understand the why behind it in a way that goes beyond the immediate stop. You're not just preventing something from being found. You're preserving a constitutional question that could matter later. If the officer indicates a search will proceed regardless, without your consent, without a warrant, claiming probable cause exists, your response is the same as always. I'm not consenting to this search, but I will not physically resist. Both parts. The first preserves the legal record. The second ensures your safety and compliance with lawful authority. The roadside is not where legal questions get resolved. Courts are where legal questions get resolved. What you do in that moment is create the conditions for a proper legal challenge later. That's all. That's enough. Now I want to spend some time on something that doesn't come up enough in these conversations. The exclusionary rule protects you from illegally obtained evidence being used against you. But there's a related protection that works in a different direction. The right to have evidence obtained properly actually be available in your defense. This sounds obvious. Of course, properly obtained evidence should be available to defend yourself. But the connection between constitutional compliance, proper procedures, and the integrity of evidence cuts both ways. When law enforcement follows proper process, the resulting evidence is reliable. When they don't, even the reliability of what was found comes into question. Chain of custody, proper documentation, following established procedure. These things exist partly to protect the integrity of evidence, for everyone's benefit, including defendants who need to challenge what was found and how. This is why the constitutional framework around searches isn't just pro-defendant, it's pro-accuracy, it's pro-truth. A legal system where searches can happen anytime without constraints produces less reliable evidence, not more. The rules exist because they produce better outcomes across the board. Let's run through some specific scenarios. Because abstract legal principles are only useful if you can see what they look like when real things happen. What if you're at your front door and an officer asks to come in and look around? Without a warrant, the officer generally doesn't have the legal right to enter your home. Your home has the strongest Fourth Amendment protections of any space. If you decline to allow entry and they enter anyway, any evidence found through that entry may be subject to an exclusionary challenge. Your response at the door: do you have a warrant? Without one, I'm not comfortable allowing entry without a warrant. If they enter anyway despite your clear non-consent and without proper legal basis, that entry and everything it produces becomes a potential constitutional issue. You've preserved it by being clear about your position. What if you're questioned and you provide statements that lead to the discovery of something? This is where the fruit of the poisonous tree gets complicated. If the questioning itself was lawful, statements made voluntarily generally don't carry the same exclusionary protection. This is one of the reasons invoking your right to remain silent and speaking with an attorney before providing accounts matters beyond just the immediate conversation. Statements aren't subject to the same exclusionary analysis as physical searches in most circumstances, which means protecting your words has a different mechanism, invoking the right to remain silent, but the underlying principle is the same. Preserve constitutional protections while you have the chance, because you can't easily get them back after. What if an officer says they have probable cause and doesn't need your consent? That's possible. Probable cause is a real legal basis for a warrantless vehicle search in many circumstances, and the specific analysis is complex and jurisdiction dependent. Your position doesn't change. I'm not consenting to this search, but I will not physically resist. Why maintain that position even when they claim probable cause? Because whether actual probable cause existed is a legal question that gets determined later, by an attorney, by a court, through proper process. Your non-consent is part of that record. If probable cause genuinely existed, the search proceeds legally, and your non-consent doesn't change the outcome. If it didn't exist, your non-consent becomes significant. You're not in a position to adjudicate that question on the roadside. No one is. Say the phrase, stay calm, let the process work. Something I want to address directly because it comes up. If I know about this protection, couldn't I just do whatever I want and then claim the search was unconstitutional? No. And this is worth being clear about. The exclusionary rule applies to constitutional violations by law enforcement, not to evidence that simply wasn't found legally in a narrow technical sense. Courts examine the totality of what happened. Probable cause analysis looks at what officers actually observed and the reasonableness of their belief. Judges and defense attorneys argue these things out through proper legal process. This isn't a loophole. It's a protection that applies when constitutional requirements genuinely weren't met. The burden of establishing that falls on legal professionals working through the legal system, not on someone claiming it at a traffic stop. What you do at the stop is preserve the question. What happens with that question is determined by law, by evidence, by proper process. Those are different things. Let me spend a moment on the practical toolkit. Same as always, short enough to actually remember. Officer, I don't consent to searches. Preserves the constitutional question at the car window. I'm not consenting to this search, but I will not physically resist, for when a search proceeds regardless. Do you have a warrant? At the front door. I'm not comfortable allowing entry without a warrant, declining entry without a warrant. I prefer not to answer questions without speaking to an attorney first, for any questioning situation. Am I free to go? In any voluntary encounter to establish your legal status. These phrases work because they create clear records. They establish your position. They preserve the legal questions that constitutional protections are designed to address. They keep options open that saying yes or staying silent in the wrong direction would close. Practice them. Say them out loud before you need them. The mechanical familiarity is what makes them come out calmly when your adrenaline is up. There's one more dimension of this that I think is genuinely underappreciated. The exclusionary rule and the protections around it, they're not just about individual cases. They're about the system working the way it's supposed to. When people know their rights, assert them calmly and lawfully, and the legal system has to engage with constitutional questions, that's the system functioning as designed. It creates accountability. It creates a record. It creates information about whether legal standards are being followed. None of that requires hostility. None of it requires confrontation. It requires knowing what protections exist, using them clearly and calmly, and trusting the proper legal process to handle what comes next. That's what an informed citizen looks like in these moments. Not aggressive, not paranoid, not adversarial, just informed. Here's what I want you to actually walk away with from this video. The protections that exist around unconstitutional searches, the exclusionary rule, the fruit of the poisonous tree doctrine, the requirements around warrants and probable cause. Most people have no idea these exist as practical operative protections. They know the rights in an abstract sense. They don't know the consequences of violations in a practical sense. That gap is what this video is about closing. You now know that refusing consent to a search isn't just about the immediate moment. You know that the constitutional question you preserve by saying no has potential legal consequences that extend well beyond the roadside. You know that what an attorney can and cannot do often depends on decisions you made before they were involved. And you know the protection's name, which means you can look it up, ask about it, understand it more deeply if you need to. That's what education does. It gives you a starting point you didn't have before. Now, here's where I want your head to be before the next video. We talked about what happens when evidence is obtained improperly. That's the exclusionary side of the coin. But there's a flip side that's equally important and equally misunderstood. What happens when you're dealing with a situation where evidence was obtained lawfully, properly, constitutionally, with all the right steps followed, but there's still something wrong with how it's being used? What about the protections that exist around the use of properly obtained evidence, around what law enforcement can claim it means, around the way context gets stripped from statements and what that does to how they look later? That's a completely different legal landscape. And most people assume that if everything was done properly, there's nothing left to protect. There is, and that's what comes next.